If you buy a house, sign a will, or finalize a car loan, you eventually find yourself sitting across a desk at a local bank or shipping center, watching someone stamp your paperwork. It is a routine, almost invisible administrative chore. Millions of Americans currently hold a notary commission, filling a quiet but strictly required role in millions of transactions every year. Yet the person holding that stamp operates within remarkably tight constraints. They cannot draft the document you are signing, they cannot offer you legal advice about what the contract means, and they cannot alter a single word on the page. This strict powerlessness is highly unusual for an office of this age. The lineage of the notary public survives unbroken from the days before the collapse of the Roman Empire. To understand why a modern American notary is so restricted, we have to look back at the absolute authority their predecessors once held and trace exactly how that power was intentionally dismantled over centuries to create the neutral system we rely on today. The origin of the office begins in ancient Rome with two distinct roles: the notary, who were highly skilled scribes using shorthand to rapidly record speeches and legal proceedings, and the tabellari, who served as the state's public record keepers. When the empire collapsed, the administrative machinery of the Catholic Church absorbed these roles. Canon law relied heavily on written records, and the Church positioned the notary as an officer whose signature and seal could grant binding credibility to wills, deeds, and ecclesiastical proceedings. By the 11th and 12th centuries, particularly in Italian city-states like Florence and Bologna, the profession reached new heights of prestige. Notaries formed rigorous guilds, required formal examinations, and became indispensable to European commerce and governance. This tradition built what is known today as the civil law notariate. In this system, continental notaries did not just witness signatures. They drafted the documents themselves, advised the parties on legal form, and wielded quasi-judicial authority over the transaction. When a medieval European notary stamped a paper, it carried a presumption of absolute authenticity. The courts were legally bound to respect their instruments, meaning the notary actively shaped the law of the land rather than simply observing it. But as that continental tradition spread north, it hit a philosophical wall at the English Channel. England operated under the common law. This legal framework placed greater trust in live judicial proceedings, oral testimony, and citizen juries, rather than placing absolute faith in authenticated pieces of paper. As a result, the English notary was placed in a much narrower box. Stripped of sweeping judicial authority, their duties were demoted to functional commercial tasks, primarily handling maritime logs, protesting bills of exchange, and authenticating instruments for foreign ports. When English colonists began establishing settlements across the Atlantic, they brought this specific, commercially focused version of the notary with them to North American ports. The American notarial system was deliberately constructed around this English distrust of absolute documentary power, cementing a totally different trajectory for the office in the New World. This map of New Amsterdam shows plots authenticated by Dutch notaries in the powerful continental tradition. When the English took control in 1664, renaming it New York, they systematically overwrote the legal framework, forcing the common law model and permanently clipping the local notary's authority. Following American independence, these common law notaries became the invisible engine of the 19th century economic boom. They certified deeds in an exploding land market and authenticated the endless bills of exchange that built New York into a global financial capital. By this point, the modern American notary was strictly defined as a ministerial officer. They act exclusively as state-appointed neutral anti-fraud officers who perform highly specific functions like taking acknowledgments and administering jurats. Today, New York enforces these boundaries through strict qualification requirements. Unlike states that require only a background check, New York mandates a written examination to ensure applicants fully understand the rigid limits of their legal authority. This legally enforced inability to draft documents, give legal advice, or influence a transaction is exactly what creates their utility. Their extreme neutrality is the mechanism that allows their stamp to be universally trusted by competing parties in any legal dispute. The centuries-old requirement that a signer appear physically before a notary was severely tested in 2020. The COVID-19 pandemic rendered in-person witnessing impossible, forcing an immediate technological reckoning for the legal system. This accelerated the adoption of remote online notarization, or RON. Under this framework, two-way audio-visual communication and secure electronic journals replace physical presence and heavy ink stamps. Yet, despite this shift to secure servers and digital identity proofing, the core mechanism is identical to what it was in antiquity. A human being is required to neutrally verify the identity and the willingness of the signer. The modern American notary public occupies a highly specific place in our society. They provide a foundational pillar for the legal system, yet remain almost entirely invisible until the exact moment their seal is urgently required. Whether it involves applying an encrypted digital signature to a PDF or pressing a medieval wax seal into parchment, human commerce demands a witness that both sides can trust to establish the official truth.
Rapid response notary. Verified. Witnessed. Done right.